Welcome back to Beyond the Red and Blues Crucial Case Law Series. Last week we had Tennessee versus Gardner. I'm going to start with our challenge question from last week. While you're on patrol, you'd notice a person break into a locked vehicle in a parking lot late at night using a baseball bat. Upon seeing you, a police officer, the suspect immediately runs away from you and attempts to flee. Can you use deadly force in this scenario to stop the suspect and effect the arrest? The answer is no. Under Tennessee versus Gardner, the Supreme Court decided the police cannot use deadly force to stop a fleeing felon unless immediate threat of death or serious bodily injury is present to the officer or the public. So for this week, you guys have all heard of Miranda Rights, but you guys know a little bit of the backstory and what the Supreme Court decided. I'll let Zach get into it.
All right, so Miranda versus Arizona, a case that is from 1966, so kind of an old one here, still something we use every day. Case basically has to do with Ernesto Miranda. He was arrested for suspicion of his connection to multiple crimes, and he was brought to a police station where he was interrogated for a prolonged period of time. After a while, he confessed, and it was taken to court, and the argument is, was that confession good or not? The jury finds Miranda guilty. It gets appealed and it goes up to the Supreme Court, and the Supreme Court decides 5-4, so kind of a close one here, that the Fifth Amendment, which protects you from self-incrimination, is important, and that police are now required, whenever somebody is in police custody, to notify them of certain things to protect them from self-incrimination. The rights that we have pretty much established now. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights? So in order for police to have to read you these rights, two things need to be present, which is custody and interrogation. So custody can be formed in a bunch of different ways. They can be handcuffed. They could be literally in police custody, like at a jail. They could be surrounded by multiple deputies or a reasonable person within that they are under arrest. They could be in the backseat of a patrol car. So there's a bunch of case laws out there that establish the various types of custody. And so custody doesn't necessarily just mean jail. And interrogation has to do with asking questions that are specifically related to the crime that you're asking about, and that can lead him to self-incriminate. So if I'm just asking him very basic information like what's your name, and there's a exceptions list including jail questions like medical questions and background to house him in a jail facility, none of those count even though he is in custody. So both need to be present, custody and interrogation. And if those two things are true, then you would have to read them in your Miranda rights.
So for this week's challenge question, as a police officer, you are assigned to investigate a recent car theft that just occurred, and you happen to just find the vehicle as well. In addition to that, there's a man sitting next to the vehicle. You approach him and you ask him if he knows anything about the car. He says, yes, I took it. It was just sitting there idling. You immediately arrest him and do not read him his Miranda rights. Does his confession of guilt be admissible in court? And I'll put the answer in the description.
If you guys have any other questions on any other case law, make sure you drop them down below. If you guys are curious about some of the other ones that we've covered, like Pennsylvania versus Mims, or Illinois versus Wardlow, or Tennessee versus Garner, make sure you guys go check out those videos. See you next week.